In recent years, Sweden has witnessed a fundamental shift in its migration and asylum policies. A shift that has taken shape alongside the growing influence of far-right movements within the structures of power and the incorporation of their discourse into official government policy. This transformation has raised serious questions about Sweden's long-standing commitment to human rights and its international obligations. The turning point of this policy change was the Tidö Agreement of October 2022, which laid out the political roadmap of the current government and directly paved the way for far-reaching restrictions on migration law, a reduction in asylum admissions, limitations on family reunification, and the securitization of migration. Within the framework of this agreement, the Swedish government has pursued a series of legislative and administrative measures officially justified as necessary to control migration and maintain public order. Yet critics argue that these policies have, in practice, led to the erosion of the fundamental rights of migrants and asylum seekers. Among the most controversial initiatives was the proposal commonly referred to as the informant law, which would have required public sector employees, from teachers and doctors to social workers, to report undocumented individuals to the police or the migration authorities. This proposal triggered widespread opposition from human rights organizations, trade unions, and religious institutions, who warned that such a measure would destroy social trust, deter children from attending school, discourage patients from seeking medical care, and effectively turn public service workers into immigration enforcement agents. At the same time, the Swedish government introduced a policy dramatically increasing financial incentives for so-called voluntary return, offering families sums amounting to tens of thousands of euros in exchange for leaving Sweden. While the government presents this measure as voluntary, critics caution that in an environment marked by legal pressure, insecure residence status, and expanding restrictions, the notion of voluntariness becomes largely illusory. The government further accelerated deportations through the adoption of the guaranteed departure legislation, extending the validity of expulsion orders, closing previous legal pathways that allowed rejected applicants to change their status without leaving the country, and intensifying enforcement mechanisms, steps that critics warn could lead to widespread detention, homelessness, and a form of indirect forced removal. One of the most sensitive and unprecedented developments has been the proposal to amend the Swedish constitution to allow for the revocation of citizenship from dual nationals under specific circumstances. This proposal challenges the long-standing principle of non-revocable citizenship in Swedish law and has raised serious concerns regarding legal insecurity, discrimination, and the potential political instrumentalization of nationality. Simultaneously, the government has announced plans to abolish the permanence of permanent residence permits for refugees, transforming them into temporary and revocable statuses and making Swedish citizenship the only pathway to long-term legal stability, a change expected to directly affect tens of thousands of people. Another critical dimension of these reforms is the severe restriction of legal aid for asylum seekers, leaving many applicants without legal representation during key stages of the asylum process. This situation poses particularly serious risks for children, women, and other vulnerable groups, significantly increasing the likelihood of unfair decisions and wrongful rejections. These developments are unfolding in a broader context in which structural discrimination and racism remain tangible realities in Swedish society, manifesting in unequal access to employment, education, and public services. In response, human rights organizations, trade unions, academics, and religious institutions within Sweden have warned that these policies conflict with the country's international human rights commitments, including the 1951 Refugee Convention and the European Convention on Human Rights, and risk undermining the rule of law and social cohesion. At the international level, human rights bodies have likewise urged Sweden to abandon punitive and discriminatory approaches and to adopt policies grounded in integration, protection, and respect for human dignity. What is currently unfolding in Sweden represents a clear example of the tension between national sovereignty and transnational human rights obligations. A tension that, if left unaddressed, risks not only weakening Sweden's human rights record, but also producing long-term social and humanitarian consequences for a society that has long regarded itself as a global model of democracy and human rights.